The information provided on this show does not, and is not intended to, constitute legal advice. Instead, all information on this show is for general informational purposes only. The information provided is not a substitute for legal advice, and we recommend viewers consult an attorney for specific legal matters.
Welcome back to Condo Craze and HOAs. Here on our YouTube channel, we are live. We are so live that the Panthers are starting their parade right now on A1A in Fort Lauderdale.
Bad timing for those of you who wish they were there.
It's so great. And you bought one of the first tickets.
I was at the first Panther game ever, yes. So just for the record, very happy the Panthers won. Ecstatic, excited. I just wish my Rangers would have won it instead. That's all. I was at the first Panther game ever, a big Panther fan. Just wish the Rangers would have won it.
And Robert's going to the parade after this, right?
That I am.
Okay.
Enjoy, enjoy.
All right, so now we're going to talk condos and
I want to
HOAs.
go down Broadway, the Canyon of Heroes. That was my intent, but didn't happen.
Canyon of Heroes.
Another 40 years with the Rangers. Okay, never mind. Forget
So, yeah, Condo Craze and HOAs. So what's going to happen here is we're going to be celebrating the Panther win and also something else. But I'm Karen Curtis with attorney Eric Glazer, and he is the owner of Glazer & Sachs, PA, board certified by the Florida Bar in condominium and plan development law. He has firms in Fort Lauderdale and Orlando, and we're here each week on YouTube, right here on our channel, to answer all your calls, emails, and chat box questions. So if you have a crazy thing making you absolutely nuts from day to day about your condo or HOA, you can contact Eric during the show, and he will try to answer your question. We'd love to get the phone line going early. It's toll free. It is 717-GLAZER-8 with a Z. That's 717-452-9378.
All right, as Karen says, don't forget to subscribe to two things. Number one, the Condo Craze channel on YouTube, where you can watch the show live, ask questions. If you miss a show, you can watch that at your convenience at any time. And as a matter of fact, I always like to say this, we built up an incredible library of shows now. So you ever want to research a topic, rest assured we did a show on it. It's great. And we're getting so many hits on that on YouTube. Very flattering, by the way. And the second thing you need to do is join our email list at condocrazeandhoas.com. By joining each week, you're going to get emails about the show, our blog, our seminars, our newsletters, updates on the law, and a whole lot more. And of course, every Monday morning, we do a blog at hoa-condoblog.com. Again, hoa-condoblog.com. And although a lot of laws got a lot of the spotlight this year, and we're certainly going to talk about a few of them in a minute.
And they take effect tomorrow.
They do. July 1st. I didn't even realize that. That's right. There's some other new association laws that passed that didn't get much of the spotlight that, believe me, all of you need to know. Okay, that I can promise.
Wow. Yeah. And by the way, don't forget that you can also follow us on Facebook, TikTok, and Spotify.
All right. Just got back from a great vacation.
Yes.
I had a wonderful time. 6 countries in 14 days, I'll tell you them. Portugal, Gibraltar, Spain, France, Italy, and the Vatican.
Whoa!
Yeah, great. Really just a fantastic
Did you see the Pope?
time. I did not. You know what the funny part? I was there on a Wednesday, and Brian, my brother-in-law, our office manager, texted me, you know, the Pope is out there speaking right now.
Oh.
I missed him by a half hour.
Oh, for God's sake.
Yeah, I missed him by a half hour. That would have been great.
Huh.
But here's the thought. European cities like Lisbon, phenomenal. Barcelona, I can't say enough about. Florence and Rome, you know, speak for themselves, right? Vibrant, clean, safe, and I mean this from the bottom of my heart. While I was there, all I could think about is how sad it is that we have these cities that are so vibrant, and then you look at San Francisco.
Oh, what a mess.
You look at New York. How does it pain me to say that? You look at
Miami.
Chicago, Detroit. No, Miami. Why? Because we have a governor that has real laws in place.
And also, Detroit is doing a lot to ameliorate.
But if you look at basically all the great cities in the United States, you can't hang out outside at 11 o'clock and eat dinner and walk around without the fear of getting slammed over the head with a hammer or stabbed with a knife. That's where we are in this country. Or all of those cities being a drug den. Am I lying about anyone? Look at San Francisco, the most. I've been in a lot of cities on this planet, and I got to tell you, there's almost none like San Francisco.
Oh, it's so beautiful.
San Francisco is beyond gorgeous. Destroyed.
It is.
And do you know how sad as an American I feel about that?
Why is it like that?
Because, well, look, you don't want to go into politics. A lot of Democrats text me on email me on Monday mornings telling me stop it. Why is it like that? We know why it's like
We beat Medicare.
Yeah, right. It's like that because at least in those countries, you have real laws. I got to tell you, when I was in Gibraltar, I'm taking a tour, and the tour guide says, and he meant this, he says, if I were you, don't even think about spitting on the floor here.
Really?
Just like that. When a law is broken here, you're going to do all the time that the law books say you're going to do. There is you do serious time here.
I heard
for breaking the
Magellan
law.
spit on the sidewalk when he passed by.
Banished to the sea forever. But these cities are beautiful. You can eat off the floor in most of them. And again, I think of what happened to the great cities in this country. How sad is it?
It's very sad.
It's
but you
really
know what?
terrible.
They can come back quickly.
You hope they can come back, but they're not going to come back with a progressive attitude. They're only going to come back when we start enforcing the laws that are on the books. You don't even have to change the laws. Just start having prosecutors that will actually
Enforce
prosecute,
laws, not make up laws.
Right, and just prosecute, not fail to prosecute and let everybody go. So, enough on that. Back to the condo and HOA world. Big news. Let's go to something happy.
Yes.
Big news. While we
Finally.
were gone, Florida Governor Ron DeSantis signed HB 1021. And Karen,
Yes.
we did it.
We did it.
We did it.
You did
We
it. You did it.
After all these years of trying, we did it. Mandatory education for all board members is now the law of the land.
You
And
started that. You had the first course.
trying to push it for how long now? I drafted the
15.
statute how many years ago, and then at the last second, vetoed. 2 years ago, it was in the bill to the last second, then removed. And it's difficult when you draft the legislation and you watch that happen. Kind of, choked me up, killed me. But it went through this year. It went through.
Congratulations.
Can't tell you how happy. We finally got a reward. Can't tell you how proud I am to have pushed this for so long.
Well, it's more than just you. It's important that these board members learn.
Oh, absolutely, especially at the
now.
Surfside. Look,
It's so important.
again, I don't want to talk about people that passed away, but if there was education, maybe this wouldn't happen, right? The tragedy in Surfside. Certainly the importance of a reserve account, and how I've been pushing so many years for it to be mandatory.
Yeah.
I think certainly the board members would have known about that had they had to go to school, But
And we're talking, what, 4 hours?
we're talking 4 hours. That's it.
And continuing
to
each year.
potentially save lives. But I'm certainly not afraid to share the spotlight, and I want to say something on the air. I want to thank listener Barry Sipko.
Barry.
Barry, calls our show all the time, and I can't tell you how much I thank him for working relentlessly with Representative Lopez. And the truth of the matter is that this does not get done without Barry's never-ending help. So Barry, if you're listening today, and I hope you are, here's to you, my friend.
Thank you,
This doesn't
Bear.
get done without you, and I appreciate your help. Yes, I drafted the statute. Yes, it was my idea, but none of it happens without Barry's persistence. So
And he
I really
continues
appreciate
to
it.
find little flaws that can be fixed.
Yeah,
and
absolutely,
stuff,
absolutely.
Which is,
He's
every
a
law has those
lawyer
types
from
of things.
Cornell, relentless. He's a dot the I, cross the T kind of guy. But the bottom line is, my ideas don't happen if not for Barry. So
And,
thank you, Barry.
Thank you, Barry. And so before
absolutely.
we take our break, you interviewed the legislator who made it all happen,
Yeah.
Vicki Lopez.
Yeah, I did, and we
And it
aired
aired
that
last week?
interview last week. Right, correct. And the bottom line is that she decided this was the year that she heard the complaints of all the complaining unit owners out there, and she drafted the legislation that those people have been begging for forever. And what's ironic or kind of interesting is that she says originally she knew very little about condominium law. Absolutely,
But
almost
one
nothing.
And
Yeah.
the legislature lives in a condo, right?
Exactly. And she said although she knew nothing, she was getting so many complaints from her constituents that she decided to start learning about it, review what was actually happening, and then she took on the role of being the person to push through all this legislation. And I got to tell you, she worked at it relentlessly, tirelessly. And she put together a bill that was able to pass the legislature basically unanimously.
Lest you think that your voice is not being heard, this is an example of her constituents getting her ear, and it worked.
Not only that, she considered this bill the Condo Bill 3.0.
Okay.
And if you listen to what she said, she's already working on Condo 4.0 for next year.
Oh, excellent.
So this is a topic that is now near and dear to her heart.
Okay.
And she is not letting up.
Well, it's smart because half the state lives in a condo or HOA community association. It affects millions and millions of people.
And it's been neglected for too long a period of time. I think, you know, the seesaw has been tilted one way for a very long period of time. And quite frankly, that was in the direction of developers. Developers were, you know, bottom line, holding the bag for so many years. And if you look at some of the new laws that have come out, like mandatory reserves even when the developer is now in charge of the property. So now when people buy a condo, they know what the real cost is of your assessments each month. Because not the fake cost of it when developers were not putting the reserve amount in there. So big change. People really know what they're getting into.
And developers have the money. They were very powerful.
They're the ones controlling the bag.
And so lawmakers were like, I can't go against the developer.
Correct, because they were afraid that they're not going to build. Well, guess what? They're still going to build. You know, I'll just say this all the time, and I've said it before on the show. When I was a kid living in Brooklyn, it used to be commercials by Red Skelton. They said, you go on, come down to Century Village, and for $200 a month, you get golfing, you get tennis, you get swimming, and on and on and on and on. And the truth of the matter is that commercial was a lie.
Yeah.
Yes, it was only $200 a month because the developers were able to put out a budget that let these new people move in and pay only $200 a month.
Right.
But what are we learning now? What was the real number? The real number was, yes, it's $200 a month, but after 25 years, it's going to be $200 a month, plus your share of the $30 million needed in repairs.
To update it.
Isn't that what really happened?
Yeah.
Right. So developers were able to get along with kind of what was fake advertising all these years.
Right.
So
no more people on a restricted budget anymore can come down here. And
no, absolutely. That was my line on 60 Minutes.
Yeah, it was.
Grandma and Grandpa who were just on Social Security, those days are gone.
That is.
And just that's the way it is now, because that's the true
The bill has come due.
Cost. The bill has come due, and that's the true cost. Now people are paying for the first time the true cost of what it means to live in a condominium. These are the real numbers.
So if Surfside hadn't fallen, we wouldn't be here.
We wouldn't be here. No, we would not have been here. Absolutely. I was pushing in 2018. I went to a board meeting where it was a lousy $300 assessment, and I had elderly people coming up to me and saying, "Please, Mr. Glazer, don't let this happen." And I'm like, they can't pay a $300 assessment?
No.
What's going to happen when it's $3,000 or $30,000? And I begged the legislature in 2018, please start some form of mandatory reserves. Some form, do something. No, they didn't do it. And what do we know happened? A few years later, a building fell, and why did it fall? We can debate all day long about whether or not the building next door was too close, or whether or not the right materials were used, or whether or not the pool deck had fallen. It fell because of lack of money. That's why the building fell. And so it's unfortunate. And I say this all the time, those 98 people did not die in vain. If any of the loved ones of those people who unfortunately perished that are listening out there or watching, please know your loved one did not die in vain. And all of these new laws is happening as a result of what unfortunately happened to all of them. But because of what happened to them, they're going to save God knows how many lives going forward. I truly mean that with my heart and soul.
How much money did the Champlain Towers need?
They needed $15 million. They had $700,000 in the bank. They were $14.3 million short in the middle of COVID. Yeah. Think about that. It was a disaster. But all right, finally I was able to watch the debate, and I'll end on this while coming back.
So you were watching it
I was
in Europe?
watching it on the plane.
Coming
back on the plane. Yeah.
Interesting. What did you think?
Politics aside, after I had a father with dementia, Okay, my father died at the end with dementia, and all I could think about while watching this was, and this is going to piss people off, I know it, but I don't care. How dare Dr. Jill Biden put her husband on the stage like that, and then at the end treat him like a little boy and say, Joe, you did good. You answered the questions. How do you do that to your own husband after such an distinguished
It was awful.
political career? How dare you do that to your husband? I would never do that to a loved one. So I think what happened to him was terrible, but I think his loved ones let it happen to him. And I, for one, thought it was absolutely terrible. Absolutely terrible. I felt terrible for the man.
It was like the Hindenburg crashing into the Titanic.
Yeah. I'm not happy about it.
No,
I'm not happy about it at all. It was awful. But in terms of where do I think we're going next?
Yes.
Well, let me spell it out in a different way. Again, this is a legal program, so I know we're talking politics for a minute. No, but let me talk about what previously happened and why and where we're in the same boat. I haven't heard a single news anchor talk about it this way, but let's talk about it this way. It reminds me of the Ruth Bader Ginsburg situation, right? Justice Ginsburg refused to resign during Obama's administration because she was positive that Hillary Clinton would beat Trump, and therefore Hillary she would step down during Hillary's administration, and Hillary would appoint her successor. And we all know that didn't happen. She passed away during Trump's administration, and Trump got to fill her spot with a conservative justice. And this reminds me just of that. The Democrats are thinking that this guy is not going to lose. They're going to lose. He's going to lose, and a Republican is going to go into his spot. So when it's time to go, just like it was Ruth Bader Ginsburg, time to go, you step down for the good of the party, and so far that hasn't happened yet. But
well, maybe they'll concentrate on Senate and House seats instead. And Dianne Feinstein voted the morning of her death.
Really?
There's
well, remember what's going to happen here
the morning of her death.
You have what's called the down ballot.
Yeah.
And if you're a Democrat, you got to be really scared that if you're not voting for Biden at the top of the ballot, the people who are below him are going to suffer as well. So for the good of the party, we all know what needs to happen, right?
But will it?
Will it happen? I don't know, because when you see Dr. Jill allow her husband to be thrown into the lion's den like that, something tells me that she's not ready to go. She's not, and will never give it up. So
he says he'll debate in September too.
Yeah, whatever. But that's how I feel about the topic. It's time for him to gracefully bow out. But let's do this. Let's hear from our listeners and viewers. You can talk about the new condo laws. You can talk about the debate, where we are in the history of our country at this point, or anything else on your mind in the crazy condo and HOA world. Give us a call in the studio, 717-GLAZER-8. Again, that's 717-GLAZER-8. That's 717-452-9378. Or drop us a question or comment in the chat box on YouTube. We'll be back right after this.
There are very large management companies, and there are very small management companies. And I think Affinity sits somewhere in the middle of that, where they are big enough to provide you with all of the back of the house services, the accounting, the infrastructure, the support systems, but small enough to be high touch.
We believe at Affinity that we do the 9 to 5 so that you don't have to do that.
Oh no, an unexpected leak. Jay, you know that's no way to solve a roof problem. Call Best Roofing. We solve roof problems.
We are DMI Paving and Seal Coating, Florida's parking lot experts. We specialize in asphalt paving and repair, including pothole repair, seal coating using JC7 or polytar, concrete curbs, ramps, and walkways, and striping and pavement marking, as well as ADA compliance. We service commercial properties, including homeowners associations, apartment communities, shopping malls, warehouses, stadiums and arenas, and more. Experience is worth more than anything in an industry like ours, and our staff has decades of it. We have specialized equipment for any job, regardless of size, saving you time and money. DMI has a reputable history. We have been in business since 1956. We serve the state of Florida from 6 locations. Let us bid on your next parking lot project. Visit us online at dmipavingandsealcoating.com.
Rimkus Consultants offer the professional expertise to help condominium and cooperative communities provide safe, compliant buildings for their tenants. We have more than 170 Florida licensed engineers and architects who are experienced with local regulations and can assist with Senate Bill 4D compliance. We can help with milestone structural inspections, capital expenditure evaluations, structural integrity reserve studies, and developer transition reports. Focusing on energy, resilience, maintainability, and sustainability, our experts can help with every phase of the building life cycle. For mitigation after a catastrophic event, building restoration, repair and remediation consulting, or Senate Bill 4D inspections, please visit rimkus.com.
Condo Craze and HOAs here on our YouTube channel. It's your turn to call and talk to Eric Glazer, who's board certified in community association law. We have phone lines pretty much stacked, but 717-GLAZER-8, that's 717-452-9378, if you'd like to ask a question as well in the chat box here on YouTube as well.
Okay, who do we got, Ron? Tell us where you're from, by the way, when you say hello.
Your name and where you're from.
Let's see. Hang on. Let's go to Francis.
Hey, Francis.
Good morning, Eric Glazer. Glad you enjoyed your cruise.
Thank you so much.
Welcome
Where are you calling
back.
from?
16th floor condo, Clearwater, Florida.
Okay, great to have you.
Question is,
How can we help?
do bios need to go out to owners if the number of people running for the board of directors is less than the total positions that our laws, our bylaws are called for?
Great question. So let me give everybody an example. It's time for the condo elections. There are 5 open seats, right? But only 3 people submit their name to run for the board. And they not only submit their name, they submit their bios. And do those need to go out if only 3 people submitted their name for 5 positions available? And the answer to that is absolutely not. Right, because you don't need an election. If 3 people submitted their name for the 5 empty seats, they're in. Those are the 3 people on the board. So what happens with those 2 available seats? Those 3 people become the board, and those 3 people can fill those 2 empty seats any way they want. So the answer to your question is no, the biographies do not need to be mailed out to anybody.
You don't even need to vote.
Because there's no vote.
Right.
There's no election coming up. That's exactly right. Okay, those only go out when there's going to be an election. And I will tell you this, just off topic for a second, if an election is required, they better go out. Because if they don't go out, that's reason for a new election. Okay? So so the statute and the administrative code takes the bios very seriously. They need to go out if there's an election, but they don't need to go out if there's no election. Okay? Hope that answers your call, your question. Okay.
Yes, it has. Thank you.
Who's next, Rob?
All right, our next caller is Arnie.
Ernie, where are you calling from? Sesame Street. How are you, Ernie?
Hi, Eric.
Where are you calling from?
I'm calling from Boynton Beach.
Okay, how can we help?
I I have at the end of my property between my neighbor and myself is 10 feet. The last 2 feet is a maintenance easement on his 0 lot line. I planted bushes on the maintenance easement adjacent to his fence as well as adjacent to his backyard. I'm told he wasn't happy, and even though they're about a foot away from his privacy fence, and the HOA is now telling me I have to move the bushes another foot, which would be off of my maintenance easement. So the question one is, he's saying he can't access his side of the fence, which is by my adjacent to my maintenance
Let me
easement,
slow it
which
down
he
for a
really
second.
could. It's just the branches.
Oh, wait, let me slow it down for a second, because these types of questions are kind of hard to answer quickly when you're throwing out these very complicated areas. A maintenance agreement is 10 feet, and
Zero lot line.
Did you plant your bushes on property that is owned by you?
No.
Yes.
Yes.
It's owned by me, but there's a maintenance
But it's
easement.
subject to a maintenance agreement.
I thought it was on the neighbor's 0 lot line.
The way this is being explained, okay, so it's on your property, but the association has a maintenance easement over the property. Agreed?
Correct. It's adjacent to his 0 lot line.
Okay, but how does the neighbor have a right to complain if it's not on the neighbor's property? That's perhaps what I'm not understanding. Now, the only people or the only entity that I think would have a right to complain about this at all would be the association if somehow by planting these bushes, it interferes with the association's right to maintain the property or get to whatever they need to get to as a result of them having that easement. I can't see how your neighbor would have the right to complain about anything, quite frankly. So, no, I don't get it.
He's saying he can't access to clean that side of his privacy fence, for example.
Okay, so, all right, that's interesting. So sometimes you have a situation where you have a person doesn't have the ability to get to their side of the house without them going onto your property, for example. And you have to look at other sections of the Declaration of Covenants, because oftentimes he may have a reciprocal easement. Check this out. You need to check your documents. And again, I hate rushing through these questions, but sometimes you can't answer these questions without me looking at your actual documents. But your neighbor's problem may be solved by looking at the documents thoroughly, because he may have a reciprocal easement over your property to paint his side of the house, for example, if that's the only way he can do it. For example, he needs to go onto your property 3 feet so that he actually has the space to paint his side of the house, because he can't do it on a 0 lot line, right? How would he paint his property? So there's other areas of the declaration which may allow him a full and complete easement over your property, and may allow him to complain about those bushes if it prevents him from taking care of his side of the house. So yes, he may be right if there's no reciprocal easement. And I know that's complicated for a lot of our listeners.
Part adjacent to his backyard, to his grass, it shouldn't matter.
Right, that I would agree.
It's only the part adjacent to the fence that may be an issue.
Then again, a little complicated, but then he probably does not have anything to complain about, as long as he always has the ability to take care of their house reasonably. Then it shouldn't be something that he has a right to complain about. Okay? I hope that answers your question, but got to keep going. Who do we got, Rob?
Thank you very much.
You got it.
Thank you.
Arnie.
Let's go to, looks like Helen.
Helen, how are you, Helen?
I'm great. Thank you so much. Helen from Miami.
Thank you, Helen.
And my question, continuing on this election theme, we had what, in my estimation, is a very strange election that just took place in my condo. Just a quick recap. It started out with a bio of one of the candidates, which was 3 pages long. And after management was made aware of this, it was sent out again via email, all 3 pages, along with the other candidates' bios.
Right.
Then, when the election took place, we had a tie. This one candidate tied with another. The attorney who was in charge of overseeing the election said that we needed a recount, but only of certain ballots. So that was done. And then just to verify that the second recount was correct, the tie was broken by 1. Then we had a third recount, again, with no explanation of what the issue was. Then the meeting was adjourned, even though we had an agenda for an annual meeting. It was adjourned, and there was a closed-door meeting held after the election, where the officers were elected, and basically it was an organizational meeting. Now, how much of this is improper, if any, and what recourse do we have?
Okay, so let's start with the fact that you say that everybody sent out a 3-page sheet, right, about themselves, their biography.
No, just one guy.
Oh, just one guy sent out a 3-page sheet.
But it's supposed to be 1 page.
Instead of, okay.
So is he disqualified because of that?
Well, I don't know if he's disqualified, but that may be enough.
But it was resent.
Okay, so it was
kept doing
resent
it.
as a 1-page?
2, no, 3.
No,
He emailed it.
All 3 pages were resent.
Okay.
The first one was mailed, the second one was emailed.
And the board did
all
all
this. Nothing was altered,
this.
even though management was made aware.
So the board allowed one person to send a 3-page while everybody else was limited to the 1-page. Yeah,
correct.
Yeah, that may be enough to allow for a new election. I'd have to look at the arbitration cases, but to me, yeah, that could be enough. That while one person was given the advantage of sending a 3-page, while the others were limited to a 1-page, yeah, that does bother me.
On the
That
second
does.
election, though, when one person, the tie was broken by 1 vote, was it the guy that sent the 3-page thing that won?
Yes.
That's interesting. Yes. Great question. So the question is, did it have an actual effect on the election? And there's certainly an argument that yes, it did, because this guy won the tiebreaker, and maybe that happened.
But then they did a
because
recount again.
Right. I'm saying he won that recount, and maybe it happened because of the fact that he got the chance to send out 3 pages, and the other people were limited to 1. I don't have a problem with the recount.
It seems like an unfair advantage.
No, I agree with that. I agree with that. That's why I think a new election may be warranted. And I don't have a problem with a recount, right? If there's a tie, right? I've done a million elections, and where there's a tie, we oftentimes go make sure, wait, let's recount this to make sure it's not a tie. Let's see if we miscounted somehow. Because if there is a tie, it's a real pain in the butt to now figure out what to do with that tie. Sometimes just
sure, but shouldn't there be a reason for why they decided only certain ballots needed to be recounted?
100% right. Why were only certain ballots counted? All of the ballots should have been recounted. Obviously,
they ultimately did do that.
I have no idea.
The original reasoning was only certain ones had to be recounted.
That just doesn't make any sense to me. Obviously, let's say we have 100 ballots in front of us, right? And there's candidates A and B that are tied. I'd go through every ballot to see how these people voted for A and B. We do the recount and see what happens. Maybe we miscalculated wrong the first time. And that's how we do it. We go through all the ballots of everybody that voted. That didn't happen here?
It did. After they initially said certain ballots had to be recounted and did recount those, then they decided they would recount all of them.
Okay.
And then the third recounting was of all of them.
Okay.
All right, but then they met behind closed doors, and what happened?
The officers were elected, but there was an agenda which was never
Okay, let's stop there. Let's
stop
stop there. Hold on. Let's stop right there. You said there was a closed-door meeting, and I guess at that meeting you said the officers were elected?
Yes.
Okay, see, this goes on, and I don't know, can't tell you why this happens in Florida, and I'm doing this, how long? 32 years, right? Even when I started, there's thought out there that once you have a board of directors, the meeting at which they decide who's going to be the president, the vice president, there's a thought out there that whole thing has to be done in secret. No, it must be done in front of everybody. Okay? When you decide who's going to be the officers, that has to take place in front of everybody. Now, there is a provision in the statute that says if those directors don't want to vote in the air in front of everybody, they can do it by secret ballot.
Okay.
But all of that is going to happen in front of everybody. So yes, there was a violation of the statute when they went into some back room and decided by themselves who was going to be
But it might be
filling
moot,
what spot.
because the guy that won by one vote had 3 pages of a bio.
Right. There's just a lot here. That
There's
may
a
be
lot.
that may be
Nightmare.
wrong in and of itself, warranting a new election. Yes, I agree with you on that, Karen. I'd have to do some research and some case law, but I do think that the fact that one person got to send a 3-page bio while the others didn't, yeah, that's probably enough to warrant a new election. But certainly, if you filed a complaint with the DBPR or whatever it may be, or filed your own complaint about the directors not having proper meetings, you would win, because that meeting at which the directors become officers, that had to take place in front of everybody, clearly, unequivocally. So several wrongs here, and I hope
And the
that answers your
management company
question.
knew about the 3 pages.
Again, you can't rely on the management company to give you answers to legal questions. We can't have it both ways here.
right.
I always say that management companies cannot give legal advice. Period. Do not look to them for legal advice, quite frankly. Do not look to them for exactly how an election should be run, how many people are needed to do what. The Supreme Court specifically says that.
So talk to the attorney.
Talk to the attorney. You know, I know sometimes you don't want to spend money on asking the attorney questions.
But now look.
Now go pay for a new election.
Yep.
Okay. Would it have been cheaper to simply pick up the phone and ask the attorney?
Yep.
Look what you're into now. Now you got to do a new election. All the costs and fees associated with that. So spend money on the attorney. What can I tell you?
What's your phone
All right.
number?
Exactly. Yes. Spend money on the attorney. Let's do this. Let's take our bottom of the hour break. Taking your call, 717-452-9378. Again, that's 717 Glazer 8, or drop us a question in the chat box on YouTube. We'll be back right after this.
Is your condominium or HOA in need of accounting services? Look no further. Gerstle, Rosen & Goldenberg is one of South Florida's largest accounting and auditing firms, as recognized by the South Florida Business Journal, and is one of the few accounting firms uniquely specialized to provide accounting services to their growing condominium and homeowner association clientele throughout Florida. With primary offices in Aventura and Boca Raton, satellite offices in Naples and Orlando, and a professional staff of 65, Gerstle, Rosen & Goldenberg is prepared to meet the needs of any condominium or HOA in the state. The professionals at Gerstle, Rosen & Goldenberg also have experience working with timeshares, cooperatives, hotel condominiums, mixed-use buildings, and ancillary operations like restaurants, spas, and country clubs. Put their 25 years experience in your corner. Gerstle, Rosen & Goldenberg, 305-937-0116. That's 305-937-0116 or grgcpa.com.
Someday, you will need insurance. And for that day, you'll be glad you wrote down Insurco Insurance and Financial Services. Why? Because Insurco virtually insures everything. They're a full-line insurance agency that'll put together the best possible coverage and premium for almost anything. Need homeowners or condo insurance? Call Insurco. Need auto or motorcycle insurance? Call Insurco. How about golf cart insurance or trailer and RV insurance? Just call Insurco for a free quote. They're open every day. From renters insurance, officers and directors insurance, and personal liability umbrellas to all types of business insurance, boat insurance, cancer policies, life, health, and annuities. All you need is Insurco. Get a free quote. They service Dade, Broward, and Palm Beach. Speak English and Spanish. Insurco Insurance and Financial Services. It's the only name you need. Office at 14401 West Sunrise Boulevard in Sunrise, inside Edmore Chevrolet.
Call 954-846-1206. 954-846-1206. That's 954-846-1206.
All over the world, people have plumbing problems. These problems can be expensive and destructive to fix. Have you ever wondered if there was a way to take care of your plumbing problems without destruction and an outrageous price tag? Welcome to Pipelining Technologies, Inc., where we specialize in fixing your problems without demolition and minimum cutting by means of pipelining. Pipelining is the ability to take a pipe damaged by root intrusion or long-term deterioration and make it new. By means of inserting an epoxy-saturated liner into the pipe and allowing it to harden or cure, leaving behind a brand new pipe.
That sounds great. How can I get pipelining in my home, commercial building, or condominium?
Simply fill out our online contact form and a pipelining representative will get in touch with you in a timely fashion, or call us directly at 561-853-5463.
Welcome back to Condo Craze and HOAs here on our YouTube channel. We've got lots of calls. We'll just go right to them.
Let's take some questions from the chat box. That's okay, Karen. All right, let's see who we got. Richard writes in, good morning, Eric. Hope everything is okay. Glad you're back. Thank you, Richard. Appreciate it. 7info3 writes, I'm living at a condo in Vero Beach. We recently switched to a new management company. How long can I go to the old management company to request items like emails, phone calls? The answer to that question is you can't go to the management company. Write a letter to the association saying, hey, unless they're the registered agent of the association, make your demand to the association in writing, okay? You could do it, certified mail return receipt requested, but unless that management company is the registered agent, pretty sure the statute says you can't make that request directly to them. Make it to the association. And the association, we now know, has to maintain generally all of these records for 7 years.
Okay. So the management company has to
Right. It's not a question of how long does the management company have these records. The association has the responsibility to hold them for 7 years. In other words, if they didn't get them from the management company, somebody better have those records made accessible to you within the last 7 years. That's the bottom line. Okay, 7 years. Okay, Helen writes in, can a unit owner sue an association in small claims court instead of going through arbitration, mediation, or going through the expensive process of hiring an attorney to sue in court? And the answer is no. You got to look at what the statute says. The statute specifically says, and the idea is to keep cases out of court. That was the idea here. We don't want to clog up the court system with a lot of condo cases, so we're going to force a lot of you to go to either mediation or to go to arbitration.
But it's non-binding.
It's non-binding, that's right, and you get the chance to go to court anyway. Right, so I hate that about the system, but that's where we're at. But no, Helen, the bottom line is, if the statute requires you to go to arbitration or mediation first, that's where you have to go.
Here's a yes or no question.
Yes.
So will an already elected board and the members of it need to take your class this year?
When you say my class,
A class.
Yes, and the answer is, so as of tomorrow, like you said, Karen, the law goes into effect July 1st, right?
Okay.
So those people will have I think it's a 1 year period or 10-month period to take the 4-hour course.
But if you already took it,
teaches you everything. Now, if you took it, the way I look at it, if you took it within the last 2-3 months that I've taught it, and I've taught all the new laws, everything that's passed, I think you're good.
Okay.
Okay, and I'm certainly willing to certify you if you took it. But starting tomorrow, you have like a 10-month period where even if you've taken the class, before, if you didn't learn any of these new laws and stuff, you have to take this class.
And you're on the board.
Even if you're on the board, even if you took a class before. Just to be really
do it again.
To spell it out, be really cautious here. Even if you took the class before, right? If you're on the board, you have, I think, a 10 or 11 month period to take this class over again. Okay, I think it's actually till June of next year you have to take this course, and you better take it, because if you don't take it, you're off the board. Okay. Here's a great question from Paula C. Can a condo association keep me from putting solar panels on my roof? Now, as we know, we've talked relentlessly on the show about making material alterations to the common elements. Well, what about putting solar panels on my roof? There's a separate statute that makes it very clear that says, despite what your condominium documents say, despite what your HO documents say, the association cannot prohibit you from making changes to your property that help preserve energy.
Unless there's Kaufman.
Well, if there is Kaufman language, there's no question that the statute applies in your association.
Or not Kaufman.
Yeah, if there's not Kaufman, there's an argument that no, that makes the community look different. I don't know. Good point. Again, where we're at is a nightmare. Exactly. But bottom line, generally teaching this is the law wants to encourage the use of solar panels in your property.
Right.
So the association cannot prevent you from putting solar panels on your roof.
What if an association is preventing you from having an open house to sell your condo and there's nothing written about it?
That's an interesting situation as well, because I'm involved in a case with a and I always got to wonder if that person is always trying to set me up here.
Oh, interesting.
But I would think that in order to prevent somebody from having an open house, you better have that in your governing documents.
Okay.
Better have that in your governing
Can't be
documents.
arbitrary, and it's
you can't
just not
make
reasonable.
rules that are arbitrary and capricious. Can you do it by rule? Is it a type of rule that's reasonable? I don't know about that. It would be a tough call to say no, a person can never have an open house. Maybe you can limit it to a certain amount of people in your property at any one time. Maybe that would be okay. But I'd feel better. I'd feel better if that type of situation was in your governing documents and voted upon by the community, not just made by board rule. Okay? Back to you, Rob. Who do we got?
Actually, let's go to Robert from Miami Beach.
Yeah.
Hey, Rob.
Yes, good morning.
Good morning.
My condo docs written back in 1972, and this is regarding Kaufman language.
Yes.
It might say as adopted, as discussed from time to time, as adopted from time to time, or from meetings from time to time, but never is there any word or any sentence that says as amended from time to
Does
time.
it now? What you're talking about? Now, what you're talking about? Does it refer to the Florida Condominium Act, or does it refer to as your documents are amended from time to time? Because there's a big difference between the two, and you got to look very carefully. A lot of times, people will call me and say, "Look, Eric, we have the language in our documents. See, it says as amended from time to time."
But his says adopted.
As adopted.
As adopted.
What does that
I can
mean?
read you the sentence.
Go
says,
read it.
In the event of any conflict between rules and regulations adopted or from time to time amended as the condominium document or the Condominium Act, the latter shall prevail.
Or the Condominium Act as amended. You know what? So there, okay. So
It
there,
does not say as. It doesn't say as amended. It just says or the Condominium Act, the latter shall prevail.
Or the Condominium Act. Okay, so then it's probably not good enough. There has to be, just to make this clear, there has to be a clear intention. When you look at your governing documents, there has to be a clear intention that this association wants to adopt changes to the Condominium Act as they are made by the Florida legislature. If that clear intention is not there, then the bottom line is you don't have Kaufman language, and the new laws that come out every year do not apply to your association unless they are procedural statutes, how to do something statutes. So the answer to that question is no, it doesn't seem like you have Kaufman language. Again, what I was trying to tell everybody is sometimes people will call me and say, look, you see it says the word as amended from time to time, we got it. And I'll say, no, you don't have it. When it says as amended from time to time, it's referring to as your bylaws are amended from time to time, as your articles are amended from time to time, as your declaration is amended from time to time. It's not referring to as the statutes are amended from time to time. So you got to be careful. But that was a good call. Who else we got, Rob?
Let's go to, this looks like Ruth.
How are you, Ruth?
From Palm Beach.
Ruth, you there? Okay, since Ruth is not there, let's do this. Let's take our final break of the hour, because I think we're due for that, all right? And if Ruth is still there, when we get back, we will go to Ruth. Don't wait for the last second to call in, 717-452-9378, 717-GLAZER8, or drop us a question in the chat box on YouTube. Be back right after this.
Is your home or condo looking old, worn out, and in need of a fresh look? Then you need PD Painting to paint your property and make it look like new again. PD Painting will first properly prepare your home and condo, and then use only the highest quality paint products. After many years in the painting industry, PD Painting has achieved a reputation for always delivering a reliable and professional finish. PD Painting is fully licensed and insured and offers a 7 to 10-year warranty. Their technicians are expert craftsmen. Let PD Painting handle all the details, and then sit back and watch them restore your property and bring back that brand new look and feel. Need a service call? PD Painting will be there on the spot. Need financing? PD Painting can offer that too. Call PD Painting at 888-416-3204. Again, that's 888-416-3204. Go to the website pdpaintinginc.com. Need painting done in your home and community? Contact the experts at PD Painting.
This message is for anyone who has taken on the important responsibility of becoming an officer or director in a homeowner or condominium association. It is also for the management companies who work closely with these caring people to make sure things are done the right way. Hello, I'm Gil Pomar, South Florida Regional President for Center State Bank, now the second largest bank based in Florida. Our bank, Center State Bank, has an amazing team of professionals who are exclusively dedicated to the homeowner and condo association market. Your job is not easy. There are repairs and new projects that need financing. There are legal and social issues that need to be understood. There are also technology and servicing issues that your residents want to be improved. Why not choose a bank that knows this business backward and forward? Why not have a local banker who will meet with you face to face whenever it is convenient for you or your board? Center State Bank has over 2,000 associations as customers for a reason. Please give us a chance to earn your business. Call Terry Russo at 954-633-1666 to make it happen. Center State Bank is an equal housing lender and a member of the FDIC.
Need an insurance evaluation, audit, or quotation for your condo association or homeowners association? If so, then you need to speak with our insurance experts at Mack & Waltz. We insure over 800 associations, and we are the clear leader in this marketplace. Mack & Waltz has been in business since 1989. We write insurance on billions of dollars of property values. We are an independent insurance agency representing insurance companies which specialize in condo and HOA insurance. The staff at Mack & Waltz works closely with board members and property managers and regularly attends association meetings to help educate the association about their insurance policies. To learn more about how Mack & Waltz can save you money and improve your insurance program, call now 954-640-6225 and ask for Greg Waltz. 954-640-6225. Mack & Waltz Insurance Group. Let us protect your association. Welcome back to Condo Craze and HOAs here on our YouTube channel. Final segment. Don't wait to the very end to call us. And the phone number to call is 717-GLAZER-8. He's the guy, Glazer, and it's 717-452-9378.
All right, let's go back to the board. Barry, our friend, writes in. Barry, again, who we owe a thank you to, and I know a couple people on here did say thank you to Barry. Thanks, Barry. All right, his question, almost every 2025 Sears Structural Integrity Reserve Study, again, the condos must do now, Structural Integrity Reserve Study, is prepared with the transfer of the non-Sears reserve assets for structural components from the non-Sears to Sears, and nothing in the condo laws requires a transfer. Okay, so to simplify what Barry is saying now you know you have to do the, for buildings that are 3 stories or more, you have to do your Structural Integrity Reserve Study, for your roof, you know, everything, all the structural components of the building, right? Roof, pavement, painting, fire protection systems, etc. Okay, so they're going to come out, they're going to do their reserve study for your Structural Integrity Reserve Study, they're going to call it. And now they in order to do the math for that, they're saying, wait a minute, you have all this money over here in your general reserve account. So we're going to take it and we're going to use it to do the math in your Structural Integrity Reserve Study. And Barry's saying, where does it say you can do that? And I think I have to agree with him. If you're going to take that money from a non-Sears account and now put it in a Sears account, that's potentially using reserve money for purposes for which it wasn't originally intended. So I think Barry's onto something here. You got to get a unit owner vote,
right,
in order to do that.
Which you'll probably get because that money is sitting there.
Exactly, because they would you'd probably
like,
get.
Oh
but
God, yes.
You have to do a vote to get it. I think you do, and it's going to be a majority of all unit owners in the association. It used to be just a majority of a quorum, no more. Now it's a majority of all units. Good question, Barry. Okay, making us think again. Let's see. Let's go back to this. Someone had a question. No, you know what? Let's go back to the phone. I apologize. Let's go back to the phone because I know somebody had a question about a metal roof.
Yeah, Beth called back, so we're going to go to her.
Oh, I thought it was Ruth.
Oh, that's why.
Hi,
oh, that's why she might not have answered.
I did kind of wrong, but yeah.
Hey, Beth, how are you?
Hi.
How can we help?
My question has
My question has to do with metal roofs.
Yes.
In an HOA. Our HOA attorney has told members of our board that, yes, we can expressly prohibit metal roofs. It is in our rules. Do you agree with that?
No, absolutely not. I absolutely disagree with that. There's a brand new statute that makes it very clear, as long as the metal roof is generally in line with the color of the colors that are being used in your community and basically the kind of style, metal roofs should be encouraged.
They're superior.
They're superior than other roofs. They're safer than other roofs, and this statute acknowledges that. And as long as a roof, it's not only metal roofs, it's roof systems that basically comply with the Florida Building Code, they can't stop you from using certain roof systems.
it's
and I
safer.
can tell you, certainly, and by the way, you can tell the attorney to look in the actual legislative notes. Okay, they do an analysis of what this statute means. House staff, Senate staff, tell him or her to look there because it specifically speaks about now allowing metal roofs because they're superior. So the answer to your question is yes, metal roofs are allowed.
Thank you.
Okay,
Thank you, Beth.
got it. Okay, take another phone call. What else we got?
Let's go to Michael from Boynton Beach.
Hey, Mike.
Good morning.
Good afternoon. How are you?
Question. Excuse me?
I said good afternoon. Did you have some drinks last night, just waking up?
Well, technically, he's got 3 minutes. It's still
You're on from 11 to 12. How can it be afternoon already?
There you go. All right, I think 12 is afternoon. How do you define afternoon? Anyway, okay, how can we help?
Right. My question concerns flying flags in an HOA community.
Yes.
We have a rule that says only the American flag can be flown in front of your house. But a lot of people since October 7th have chosen to fly Israeli flags as well.
Hey, what flag? I'm sorry?
And-
Yeah, Israeli flag. Okay, gotcha.
Okay.
Yeah.
Yes, and the board has received some complaints about this, and the board is getting ready to tell people to take down their Israeli flags.
Yeah. And
I say not so fast.
Well, the board is going to win that. Okay.
Well, wait a minute, Eric.
Yeah.
Eric, I'm on the board, and I want to introduce an amendment to our rule. The amendment I call is the war exclusion.
Oh.
And it says if a country that you care about is at war with another entity, and the country that you care for is a country recognized as such by the United States government, then you can show your support for that war, for that country, by flying their flag for the duration of the war.
They did that with Ukraine.
What is your right? Exactly, that's happening. What does your board think about that?
He's on the board.
Right. What does
My
the whole board think about that?
Is inclined to agree with this amendment, actually. But I wanted to run it by you.
Well, it's interesting. So what does the statute say? The statute gives you a right to fly certain flags of the United States of America. So it gives you the right to fly our normal flag. It gives you the right to fly flags relating to the armed forces. Now it even gives you a right to fly flags related to first responders.
Okay.
So the statute's been amended. It does not say you can't fly flags from other countries. Interestingly enough.
Oh, okay.
So I think if the board made a rule acknowledging the statute, but saying we're in addition to the provisions outlined in 720 whatever or 718 whatever, we adopt the following rule, which allows people to fly additional flags, might work. I think it could work. I don't think there's. I can't think of a reason why it might not work, unless someone challenges that as being unreasonable. Because why can't I fly a flag of a country that is in opposition to the United States of America. Isn't that the right, the First Amendment rights we have here?
It is. They
Now,
can.
no,
They
hold
can.
on,
I'm
hold
not
on. But
saying
there
they
are,
cannot.
right, but
So,
there are other
because-
cases, hold on. But there are other cases that say, wait a minute, when you move into a condo or an HOA, you basically give up a lot of your First Amendment rights. For example, you don't have a right to put up signs in front of your house.
Wait,
right?
remember I sent this to you, the guy in the HOA who had a Trump flags on his boat that was in his dock
Right.
behind the house?
Yes.
And they said you have to take those down, so he wrapped his boat
With
with Trump.
with Trump.
Can he do that? Can you wrap your boat?
Well, now I can say this: if you're putting your boat in your backyard, brand new HOA, I'm really being tested here with all these new laws. You put your boat in your backyard, and if it's something that can't be seen from the front,
you're good.
You're good. You're absolutely good.
Boom.
Yes.
So, but back to the flag issue. Again, it could be argued that it's unreasonable because I live in, my position, my heart is with a country that's in opposition to the United States at the moment. I'm from Iran. I want to fly the Iranian flag, and you can't stop me. You're
Or
only
can you
allowing
wrap your
Israel.
car with it?
Can you wrap your car with it? That's a good question. Maybe you can. But I think it's not an unreasonable. It's not you're giving people more rights, and that's how I'd make the rule. In the rule, I would say the board acknowledges the statute and in effect wants to give the people that live in our community additional rights to fly additional flags. Okay, I think that if it's done that way, why not?
it's fair.
What makes it, unreasonable? I don't think it is, and I think I think my original answer was the board's gonna win that fight to take it down, and I'm gonna change it. I have my right to change it, right?
Yes, you do.
I have my right to change it because you ask questions on the fly here. It isn't
No,
easy.
you have the right to change
So
your
I'm
mind.
gonna go with the board has the right to do it if the resolution is very clear, just like I said it should be. Okay.
That all flags.
Yeah, and I hope that answers your question. All right, love that question. It's a
Thank
great.
you very much.
You got it.
That's
Great,
interesting, right?
Great question.
All right.
To end the show.
That's great.
Thank
We
you.
could go on
Thank you.
forever.
We could go on forever. And again, there's always people on hold when
Sorry.
when the show is over. I apologize for that, but hopefully you'll call back next week because it's our love, joy, and honor to answer your questions each Sunday. Believe me. And we'll be back here. I'm back from vacation. We will be back here next Sunday at 11 a.m. on Condo Craze and HOAs. If you need legal help off the air, please give me a call in my office.
Oh, you're a lawyer.
I am. Glazer and Sachs, please give me a call. 954-983-1112. Again, 954-983-1112. And we will see you and speak to you again next Sunday at 11. Everybody have a wonderful, safe, healthy week.